Unpopular presidents, disenfranchising young voters, targeting immigrants for political gain. It all sounds like today, but actually the story is much older. To understand this story better, I talked with one of the country's leading immigration lawyers, Heather Poole. Thank you so much for joining me. If you don't know, Heather and I are both immigration lawyers, but we practice in two very different parts of immigration law. I focus a lot on artists and entertainers and entrepreneurs, people looking to get status. Heather focuses on people who have run afoul of the criminal justice system or perhaps have been deemed inadmissible by the US immigration system. Years ago, there was a really famous case that's been kind of forgotten, but has a huge amount of relevancy today. It's about abuse of power, disenfranchising young voters. It's about how the interaction of drug law and criminal law interacts with immigration law. And we thought it'd be really interesting today to talk about John Lennon and Yoko Ono's immigration story. So Heather, if you could take it away and let us know, like, who is John Lennon? What time frame are we talking about? And why is this relevant for today?
So John Lennon was a very famous singer. He was the lead singer of the Beatles. He famously departed and had a solo career. And what we're today started in June of 1970, following the Civil Rights Act of 1905. Prior to that, you could not vote if you were under 21. So the Voting Rights Act expanded not only the right to vote in national, state, and local elections to citizens who are 18 and older, but then at the time, President Nixon, who was concerned about singers that were famous like John Lennon or anyone else who could have influence on his reelection campaign and could learn to vote, he didn't like this because that meant new younger voters could vote him out of his second term of office. So he fought the legality of the passage for 18-year-olds. And so it forced Congress to actually make an amendment to the US Constitution so it could never be overturned really easily by Congress again. So 18-year-olds had the right to vote. And this really scared Nixon because now it was really solid law. And to him, one of the most influential people on young people at that time was this singer, John Lennon. And John was very active in the anti-war movement, give peace a chance movement. He would have these famous sit-ins, which basically in his New York City apartment that he shared with his wife Yoko Ono, and talked to the press about political activities and why he didn't approve of Nixon's policies. And Nixon was so afraid that John would have such an impact on his reelection campaign that he had the Immigration Service at the time look very closely at John's immigration status. And John was here in the United States, even though he owned property here in New York. He was here with his wife Yoko Ono on a visitor's visa, which all of you know is considered B2. And so he was here temporarily. He had to come in every time and only could stay for a certain amount of time. And so the Immigration Service, if he overstayed by even one day, right, or applied for an extension and it was denied, John would have to go back home. So they were looking really closely at this on the direction, they think, of the president at the time to capitalize on John's immigration status and use that as a way to get him out of the country so he wouldn't have that influence on these younger voters.
So let me recap. So here it is. It's 1971. President Nixon is going for re-election. He's not popular with young people. The war's going in Vietnam. The draft is going. People are really upset. They want the war to be over. They want the draft to be over. And here John Lennon is, a Brit, agitating against the war with his wife Yoko Ono from their Manhattan apartment. And so now Nixon is trying to get John Lennon deported. So how did Nixon try to go about it?
So this is relevant to what's going on now because the issue of prosecutorial discretion really came up during this time. So the government always has an option of who they want to prosecute, right? Who they want to put in removal proceedings, who they want to go after. So this was a very famous example of going after someone because the executive wanted him gone. And it was Their decision, the minute that John was no longer able to stay on that B2, to put him into removal proceedings. And then in removal proceedings, the issue came up with his conviction. He had a conviction for cannabis that was found in his London flat when he was not home, when he was actually renting it out to someone else. But the rules at the time, the criminal code at the time in England, allowed him to be convicted. And his attorney, his criminal attorney at the time, said, it's not a big deal, not understanding the US consequences of taking a no contest or guilty plea, to just getting rid of this petty offense. So he took the conviction on the bad advice of his criminal attorney, and he would have to apply for what we call a non-immigrant visa waiver every time he came into the United States, or at least every time he applied for that B2. And the non-immigrant visa waiver would attach to that visa, but it wouldn't allow him to stay here permanently. And it was really up to the discretion of the consulate whether they wanted to waive that drug conviction, even temporarily, to allow him access. And it was a really sad situation that the only reason John and Yoko kept coming back to the US at that time was primarily because Yoko was in a custody battle with her ex, who kept not showing up to the family court to decide the custody issue. So they kept coming to court and he wasn't there. So he was trying to be supportive and be there for his wife, but then he got into all of this immigration trouble, when he overstayed his visa.
So let me get this straight. So John pled guilty or no contest to a very minor drug offense in England. So not in the United States, but in England, related to cannabis. And it's arguable whether or not this cannabis was even his. Someone was staying at his house. And I remember you saying it was like in a film canister that could have been trash. It could have been, it's very suspect whether or not this was even John's cannabis. But he pled guilty to just get rid of this minor offense, right?
Yeah, I mean, there was a famous interview with him where he thought that actually it was probably planted, because they didn't trust the London police either. So they were making sure, before he rented the place out, that it was that there was nothing there. So, there was just, because he was so popular, that he was so vocal in his political opinions, he questioned this whole thing, that he was set up, basically.
There's a really famous interview that Heather alluded to between John and Howard Cosell. I'll put a link in the description below. It's fascinating to hear John's opinion about why he was targeted. And Cosell, this legendary journalist, a little older than John, really was open to the idea that perhaps there was a conspiracy to plant this evidence. But so what happens next? So John's denied. And he doesn't have an immigration lawyer. How does he represent himself, even though he's like this famous world-class celebrity? What does he go and do?
So he interviews multiple attorneys. He goes to the record studio, Apple Records, who represented him, and they found this attorney for him. And the funny story is, this attorney didn't even know who John Lennon was at the time. He was the most popular figures in the world. But he was a really smart guy, and he stayed with him throughout the entire deportation case, doing many of the tools that we use today, like Freedom of Information Act requests. When you tried to apply for an extraordinary ability visa, an ability for him to stay here permanently, which is one of Joe's main practice areas that we'll talk about. But then he found out through a FOIA that the government had just sat on the case, hadn't decided it, and they hadn't even opened the envelope it was filed in. So it was definitely, a political prosecution. And he was worried, that his attorney was worried John was going to be deported before they even decided the green card case that would give him some relief in deportation proceedings, because the government was intentionally sitting on it.
Government delays in immigration cases is something that you and I work with a lot. And increasingly, you and I are having to go to federal court at great expense and great stress to our clients just to get some basic action, which I think a lot of people find to be, even in the community of lawyers to be outrageous, that you would pay money, you'd pay filing fees, and the government just sits on a case and does nothing. But here, it looks like it might have been deliberate. Don't even open the package to John Lennon's green card application and get him deported because he's an anti-war protester and sort of this countercultural figure. So what happens next? It goes to court. Lennon versus U.S. 19.
So Lennon versus United States. He had to go to federal court. The plan was based on his lawyer thinking that the government would force them to deny John's case and grant Yoko's. So the government would be in a very uncomfortable position, a bad PR, forcing Yoko to choose to stay here with her child or go back to England with John. He believed, the lawyer believed, that you'd be able to argue selective prosecution, right? The government was going after John intentionally as opposed to someone else in this situation, and get the deportation charges dismissed. Well, John and Yoko thought that was a great idea. His attorney was able to get a 1-month extension on the visitor visa and got to work on the permanent residency applications, and then find out they do nothing on it, right? So they have to go to court because everything was denied. And the federal judge looked at the reasons why the immigration judge denied, and a main one centered on the criminal conviction for cannabis, that he was ineligible for a green card, even if he were to win on the actual immigrant visa based on his extraordinary ability, right? He couldn't get it because he had this ground of inadmissibility based on a controlled substance violation, which is a conviction and ground of blocking a green card under federal immigration law. So this was all about whether that conviction fell within the definition of controlled substance. And to this day, unfortunately, marijuana is a controlled substance on the federal schedule. And that's how you determine whether or not a drug that you've done is going to block you from getting a green card. And even today, there is a waiver available for those who are, caught with some hashish. More than a joint, but it's probably a small bag of dried marijuana. But the difficulty that immigrants find themselves in now is, hey, this is not fair, because marijuana is legal in a lot of states now. So how can it still be illegal on a federal level? But they don't care that it's unfair.
Yeah, so
And
I just want to underscore that. So here in Los Angeles, I could walk to the weed store and buy whatever I want legally and in a controlled way. Here in California, in Nevada, in a multitude of states, and in other countries. So what happens if a person admits to using marijuana in a admissibility kind of setting? Will an immigration officer allow a person into the United States who has marijuana on them?
So on them, no, you're going to be denied entry. Now, the only exception is that 30 grams or less. And the problem is, when the definition of conviction, there's two problems. Under immigration law, you don't even have to have a conviction. They can just find it on you, and they can deny you access. They can find it in your blood. So if you go to, let's say, an adjustment of status interview, right, a green card interview, and you're in California and you use marijuana to fall asleep, right? So it takes a long time to get out of your blood. And it comes back in your medical results. You're going to be inadmissible for at least a year, and they're going to retest you, right, to see if it's still in your blood a year later. But if you have an actual conviction, then you have the burden now. The Supreme Court has made it much more difficult, where they put the burden on the immigrant to prove that what the grams were, right? You can't just say, yeah, it was a joint, or it was a baggie, right? You have to go back to that police report. You have to go back to whatever documentation. It may be nothing in the police report. It may be in the criminal complaint that was filed against you for possession, that you luckily had the DA said, yeah, it was 15 grams, right? But it's very uncommon. And so it's unfair, because the burden's on you to prove how much grams it was. And if it's not there, you're going to be denied from getting a green card. So it's not only the amount and the burden on you to prove it, but also if you say in an interview, even if it doesn't show up in your blood test, you say in an interview, yeah, I regularly smoke marijuana, or they're looking at, let's say it's a marriage interview, right? And they're looking at your husband's and your bank statement, right? And they see that you two visit dispensaries, right? That you've made some purchases there. It's going to open up a whole can of worms. And if they think that you've admitted to possession of a controlled substance, marijuana, then you're going to be denied your green card.
So that's an interesting one. I hadn't heard of that one before. So you're at the green card interview. You're presenting, say, a joint bank statement to show that you share your finances and you are a real couple. And in there is a notation that you were at the MedMen store on Santa Monica Boulevard and you spent $50. And the immigration officer could imply that you bought marijuana, that you didn't buy, say, merchandise or something, like licensed merchandise, like a fanny pack or something, and then deny you on that basis?
Well, they have to. What I'm saying is, it's not automatic. It's going to open a line of questioning that you may not be prepared for.
Right.
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 So if you lie and say, oh, I didn't get marijuana there, I got merchandise, or it was my husband, or whatever, and they somehow find out later, you have just committed a even worse sin, which is misrepresentation, which is a lifetime bar. It does have a waiver available in limited circumstances, but otherwise it can be a lifetime bar to any green card application. So you have to be really careful and review, not only prepare for any interview, but also review what's in your documents that you present. And be very careful if you're going forward with your husband, here's Mike and John in front of Judy the examiner, right? And Mike is thinking, hey, this is California, it's legal here, right? And the officer asks, have you ever had any issues with marijuana? Have you ever done any marijuana? And you say no, but then your husband says, oh, I bring it home to, it can create a mess for you. So just be very careful. Another reason to have an attorney present who's aware of these issues, if you can afford it.
What about, say, a musical artist who raps or has lyrics about using marijuana or even harder drugs?
That's a good one. They're advocating for, they could argue, I guess, that they're advocating to commit a federal crime, right? They would have to argue that they're not talking about personal experience, that it's all artistic expression, right? So that's a tough one. But you can also argue that there's a difference between a formal admission, right, and just saying something in a song for artistic expression. Formal admission, which is the same thing as an actual conviction. So a formal admission of, let's say, doing cocaine requires that you're signing a statement in front of the officer. The officer has gone through every single one of the legal elements in the penal code with you, and you are understanding and agreeing that you did this. So the difficulty is you should never sign anything in an interview without an attorney present. And second, sometimes the immigration service gets it wrong and they'll deny you on admission when they haven't followed the requirements of what a formal admission is to make you inadmissible. But there's other grounds of drug issues that can also get you in trouble, not just a conviction or an admission conviction, right? You can get barred for at least a year due to, if they think that you are a drug abuser, right? If based on either what you're telling them, even if it's not a formal admission, but based on you being arrested but never convicted for something, right? You have to be very careful because there's multiple grounds, and that's a medical ground they can get you on. If they think you're a drug abuser or a drug addict, they don't force you to go through another medical a year later. And that's another thing. You got to be very careful when you're going through these medical exams with the CIS approved doctors, right? You may not think to take this as seriously because you're not at immigration. It's not an immigration officer, right? But it's their job to see if there's any medical grounds under the Immigration Nationality Act that would bar you from a green card. And that's what the officer's opening at your interview is that sealed medical, and they're going to see the comments of the doctor. So this is not a confessional. This is not where you tell the doctor, I did weed last night, and I do it regularly. I do some cocaine. You don't. You want to say as little as possible, just like you're in front of an immigration officer, right? And the only way you can really prepare besides doing that is not having any drugs in your system and knowing how long it takes to get out of your system before you have that CIS medical exam.
So the bottom line is that even what we would consider a very minor drugs issue in 2023 could have huge, lasting, expensive, and maybe fatal consequences for someone looking to get an immigration status.
And think about the people who are outside of the United States. There is this scary law that says, you don't even have to have a conviction. You can have an arrest for, say, you're arrested for a large amount of pot, right, that they found in your suitcase. Or not even in your suitcase. Let's say you were swept up with a bunch of other people, right, in a cocaine sting that the police conducted, but then the charges were later dismissed. There is this provision under federal immigration law that says if they got reason to be suspicious that you are a drug trafficker, they don't even need a conviction for that. And drug trafficker, you may start laughing at that. Well, gosh, that's a heck of a lot of how much? There's no minimum or maximum, right? It's whether the government has a reasonable suspicion, and an arrest may be considered a reasonable suspicion. I mean, even for our student visas holders, right? If the consulate that issued the student visa finds out that you have been arrested for a DUI, they can pull and revoke that F1, that student visa right away. If they think that you have been, they notify that you're arrested for possession of a controlled substance, they also can pull your student visa and revoke it. They don't do that as often as they do on a DUI, but it has been known to happen. So you got to be very careful, because the minute you leave the United States, you're not going to be able to come back on that F1. It's gone. You're going to have to re-interview, and good luck convincing them that you're no longer a drug addict.
It's a lot to think about. And I think the bottom line is that hiring qualified immigration counsel who really knows what they're talking about, someone like Heather, is the way to go, especially if you've got any questions about drugs convictions or prior arrests, even a caution. If you're a British person who's been cautioned for drugs or alcohol, this could be a real problem. So being prepared and planning ahead for the tough questions is the way to go. To wrap up, Heather, so how did things land with John Lennon? I mean, we know he was tragically killed, but before then, was he able to get any kind of relief in the United States? Was he ever able to get his green card?
So finally, I believe it was about 5 years before he was killed, the case was settled. The court held that the analysis of British law that the immigration judge did, and how the law existed in 1968, would hold a person who was found just with tablets that he had a reasonable belief were aspirin to be guilty of the crime if the tablets proved later to be cocaine, or heroin. So the court said that there's such flaws in the actual British law that even if the person didn't know that they were in possession of a controlled substance, right? If they thought it was aspirin, that's enough. And that does not qualify for a knowing possession under federal immigration law. So he won in the end, and the court, in a very scathing decision, instructed the INS, which is now CIS, said, be very careful, because deportation, of course, is not a penal sanction, but its severity sometimes surpasses all of the most and the worst criminal penalties out there. So it's important that, and the court said, look, we think that there may be a intentional prosecution here by the government, right? And the court clearly warned the government not to screw with the immigration case once the case was won, that the conviction was not going to be a bar to the Lennon's green card, right? So they said, if you come, we're going to allow whole nother action, an APA action, an American Procedures Act action, to say that this decision was arbitrary and capricious if you deny the green card case, because there's no other ground for you to deny it on now that the criminal ground, the drug ground is gone. So we're really going to let the Lennon's attorney talk about Nixon and what he's doing and what the government's doing here. We're going to open that whole can of worms if you deny these cases. So it's a nice threat by the federal court. And so in reality, the John got his green card without a problem, because probably the government didn't want to have any bad PR after that. And it was a long case. I think the case went on for 5 or 6 years, maybe longer.
Yeah. Yeah. So I think, Heather, thank you so much for that. Every time I talk to you, I feel like I learned something new. And the bottom line is that some of the things that were happening in the early 1970s are still very relevant to today. And as as our culture has changed when it comes to, especially to marijuana, the law hasn't changed. And it's great for people to just be aware of these things. I'll put more resources about Heather and myself in the description below. Heather, thank you so much for joining us.
My pleasure.